In summary, this motion to revoke unadjudicated probation states that on August 29th, 2024, that would be a year ago, over a year ago, that in this court, criminal district court, you were placed on 10 years deferred or unadjudicated probation for the third-degree felony of engaging in organized activity. Allegation 1 states you committed the offense of unlawful use of a motor vehicle on or about January 2nd, 2025 in Harris County, Texas, which was a violation of condition 1 of your deferred or unadjudicated probation order, which states that you shall commit no offenses against the laws of this state or any other state or of the United States. Is this allegation true as it is alleged?
Yes, sir.
You can now be found guilty and sentenced to no less than 2, no more than 10 years confinement in prison.
Yes, sir.
Knowing that, do you insist on pleading true to death?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true to this motion to revoke probation.
Yes, sir.
All right. There is no agreement, right?
No, yeah.
Okay. Then the defense can go first. What do you suggest we do?
Your Honor, if it's okay, I'll just call him as a witness and we'll try away. Hey, Jordan.
He's already sworn in.
Yes, Your Honor, yeah. And you just pled true to the allegations. Is that correct?
Yes,
Okay. And you're not trying to say you didn't do what they're alleging, correct? Okay. But while you've been on probation, besides these allegations, how do you feel that you've been doing?
I feel that I've been doing good. I know I made a mistake, and I all up to my mistake. I take full accountability of it. I feel like I can complete my probation and get it done with, and well, go by my business. I feel that I did everything, but I was just the thing I did was get your charge. I was standing, I was reporting, I was testing my lawyerly, so that's how I feel.
Okay. That's what I'm getting at. You feel like you've been doing really good on probation, except for this new charge they should do that.
Yes, sir.
Okay. Are you caught up to all your fees?
Yes, I think I'm tired of a couple of months behind.
Because you said you've been in jail.
Yes, sir.
But before you went to jail, you're
Yes.
as far as community service, all the classes, everything you're supposed to be doing, you're up to date on that, you believe?
Yes, sir.
Now, obviously, since you've been in jail, you're behind on that. But when you went to jail, you were up to date.
Yes, sir.
Okay. Everything going good on probation.
Yes, sir.
You were checking out like you're supposed to,
Yes, sir.
doing everything you're asked to do.
Yes, sir.
Okay. And as far as these new charges go, you're going to face them and take care of them when the time comes for those, correct?
Yes, sir.
Okay. But you didn't want to waste this court's time anymore. Want to be done with this, correct?
Yes, sir.
Okay. And what are you asking the court to do in this case?
Oh, and if I can, with a chance to raise channel to find myself or anything else and go to still off the medicine and get to not to medicine back.
So, and that's what I'm getting at. You're also willing, if the court wants to send you some kind of treatment program or something, well, first of all, if you decide to do that, you can't say no to it because it says call. But you're willing to do that and willing to do whatever it takes.
Yes, sir.
Okay. And you're going to cooperate with the probation department and do whatever you're supposed to do.
Yes, sir.
Absolutely.
This incident happened on January 2nd, 2024. Yes,
Yes, sir.
it was at 4 o'clock in the morning. Yes,
Yes, sir.
at Dwellingbrook Apartments there in Baytown.
Yes, sir.
You were arrested not only for the offense that you pled true to, but also for evading detention with a motor vehicle.
Yes, sir.
At the time in which the officers responded to this, you were in that Kia Optima trying to move out of a parking spot without the lights on, basically just trying to avoid being detected, correct?
Yes, sir.
When they went to stop you, the officer saw you, you made eye contact, but yet you put the car in drive and tried to reverse out of there and avoid the officers where the evading came from, correct?
Yes, sir.
But they caught you within the apartment complex, didn't they?
Yes, sir.
Because you were trapped. Yes?
Yes, sir.
But for whatever reason, Harris County chose not to charge you with the evading, but the truth is that you're arrested for that. It's actually what happened. And all this was at 4 o'clock in the morning when you weren't even supposed to be anywhere near that location. You're supposed to have been at home, abiding your curfew.
Sir.
You were placed on probation for engaging wasn't that also because you were involved with others about burglaries of vehicle?
Yes, sir.
So you're telling this court that even though you got arrested and charged with it here in our county, given the opportunity to get probation, that you quote unquote learned your lesson by going to a different city and committing the same offense?
Yes, sir.
So one more time, Mr. Dell, why should we put you back on probation?
Because I know I think that I made a mistake.
That's not a mistake, sir. Or explain to him why you think that's a mistake.
Feel like it was a mistake. 'Cause it was a poor decision I made. I was wrong to was not take full accountability, but I know I didn't know existed.
I don't have any other questions, Chuck.
Go ahead, Jeff.
No more often this way.
Can I see the pre-sentence report?
I was looking for my copy. My last probation officer has it handy.
Thank you, Jeff. Stand by, I mean, peruse. There none. You have anything showing a probable cause affidavit on this new substantive offense that he's pleaded true to?
In all fairness,
Because I don't
Judge,
have anything in my file.
because I had this officer available to testify, I'm gonna hand you his report. He's the main one. He was the one I was questioning.
How much was paid back on restitution, by the way, if anything? From probation, did we know?
Nothing has been credited to the probation. I mean, I'm sorry, to the restitution. There's been a total of $704 paid. But I will amend it for it to go to restitution. If you choose to think something.
I had that officer and another officer on standby to come prove up these accusations, Chuck. But going to bring this other officer judge who details how they had to pin Mr. Dell in order to take him into custody. It also indicates the search incident to what was in his possession. Although it's not alleged, it's certainly a note to.
Looking at the earlier pre-sentence report, which shows the defendant was convicted in January of 24 for burglary of vehicles, convicted on June of 24 illegal possession of a controlled substance, and convicted in June of 24 illegal possession of marijuana. And what do I ask them to that July 9th, 2019 illegal carrying of weapons case out of Ascension Parish, Louisiana?
He has three,
When? They know where he is.
I'm sorry, 2 active misdemeanor warrants and 1 non warrant. Eric.
And in this report, it states that in that Ascension Parish, Louisiana case, that the court proceedings began in 2019, at which time the defendant was arraigned and pleaded not guilty. However, he failed to appear for court on several occasions thereafter, resulting in a bench warrant being issued in 2021, which remained active. So he's got that going on. And okay. Thank you. Yes. Thank you. Yeah, I mean, Right. I'm looking at a Baytown Police report dated January 2nd, 2025. Is that right?
Yes, sir.
Which is what, which involves the matter allegation number one, the defense pleaded treat this motion to revoke probation. Let's I observed the subject attempting to drive off due to the positioning of Officer Peaks and my vehicle. The subject sideswiped a silver four-door Cadillac before driving off towards the west side of the complex. The subject evaded about a quarter of a mile inside the complex, but was cornered near Building 2 and the exit gate. He again attempted to make a way around patrol units, but was pinned in by Officer Peak and myself. Officer Peak used his vehicle to pin the front of his vehicle, and I pinned the front wheel well area. I exited my unit, threw down on the suspect who was moving to the front passenger seat. He began exiting the vehicle through the front passenger window, but was met there by Officer Peak, who took him to the ground. He was then handcuffed by Officer Mitchell. A backpack was removed from the subject. He was searched by myself and Officer Mitchell. I later learned that the vehicle subject was driving was a fresh stolen vehicle. I later contacted the registered owner of the Cadillac, and she stated she wants nothing to do with the vehicle. The vehicle was registered to her, but was brought to her brother-in-law, who has since sold it. Completing inventories of the subject backpack and found 3.8 grams with packaging of marijuana. I submitted for disposal, and the remaining items were submitted for safekeeping. Also, 2 pairs of shoes, 1 speaker, 2 cell phone charging cords, 1 vape, 1 Apple AirPod, black Apple iPhone with scratches all over it, 1 black Apple iPhone with a broken front and back, a screwdriver, and purple cotton sack with coins. All right. Oh, that's another reason why under the justice. The everything. And this was just another burglary. Which is what he does. Hadn't learned a lesson on my watch here. You were committing that crime how many months while on probation? Let's see. September, October, November, December, 4 months. Come on. Anything else?
Not from the state, Judge.
What are you asking for? State and defense?
Judge, my opinion is that it would be a shame on us if we continue him on probation. Yeah, I've heard you say that same thing many times. And I take it to heart whenever you say not on my watch. And I feel the same way. We gave Mr. Dale an opportunity because his record did not show a felony conviction. It was a post PSI that gave us the detail of all the other crimes that he was accused of and the misdemeanors that he's been convicted of. But unfortunately, Mr. Dale did not get the message, did not make any serious attempt to complete probation, and it would be a shame on us if we don't send him to TDC. That's where he needs to go. My opinion is because he committed the same crime, that it'd be for a period of at least 5 years.
Our position is to continue him on probation, Your Honor. He stated that has been doing well on probation, except for this new slip up that he did. He took responsibility for. He's still got to face those charges for that as well. That's coming up after he leaves here. I assume that he's going to be heading over to Harris County. It is Harris County, right? I know it's Baytown, but I know part of Baytown's a chamber. So to take care of these charges, my request is keep him on probation upon resolution of whatever they do in Harris County for him. Assuming if they give him probation over there, run concurrently, and they go from there. And if not, if he gets prison out of Harris County, then when he gets off prison, back on probation and serve out the rest of this term.
Did you want to say anything, sir? You can if you wish.
No, I just want to say, I'm sorry, Don. That's it. I'm letting us show.
Anything else? If not, then I'm going to make the following findings, sir, that there is sufficient evidence supporting this motion to revoke unadjudicated probation to grant it by a preponderance of the evidence or greater, as allegation 1 has been proven true in this hearing, and the court finds that your deferred or unadjudicated probation is hereby revoked. In this case, earlier, you pleaded guilty voluntarily to the 3rd-degree felony of engaging in organized criminal activity. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this 3rd-degree felony of engaging in organized criminal activity. I now find you guilty beyond a reasonable doubt of the offense, and I am hereby sentencing you to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. It's the same kind of wrongdoing within just a few months of us putting you on probation. Also, the judgment shall reflect restitution is owed in the amount of $3,883. Anything else on this? That is all, sir. You have a right to appeal this matter. This was not an agreement.
Right.
So you have a right to appeal this revocation. Discuss that with your attorney.
And just like that, the judge makes his decision, probation revoked, and a 6-year prison sentence handed down. To understand why this outcome was almost inevitable, you have to look at the bigger legal picture that unfolded throughout this hearing. First, the most important moment happened right at the beginning when the defendant pleaded true to the probation violation. In probation revocation hearings, that admission is extremely powerful. Unlike a regular criminal trial where prosecutors must prove guilt beyond a reasonable doubt, probation violations only require proof by a preponderance of the evidence, basically meaning it's more likely than not that the violation occurred. When a defendant admits the allegation outright, it essentially removes the biggest hurdle the state would normally face. But that alone wasn't the full story here. The judge clearly focused on a pattern of behavior. Remember, this defendant was originally given deferred adjudication probation for engaging in organized criminal activity, a serious felony charge. Deferred adjudication is essentially a second chance, complete probation successfully, and you avoid a formal conviction. Fail, however, and the judge can enter a conviction and sentence you to prison for the full felony range. And what happened here? Within just 4 months of receiving probation, the defendant was arrested again, driving a stolen vehicle at 4 a.m, attempting to evade officers, and violating his curfew. To the judge, that timing mattered. The court had just extended mercy, and almost immediately the same type of criminal behavior appeared again. Then came another critical factor: criminal history. During the hearing, the court reviewed prior convictions and pending issues, including burglary-related activity, drug possession cases, and even warrants out of Louisiana. While those may not all have been the direct reason for revocation, they helped paint a picture for the judge that this wasn't simply a one-time lapse in judgment. Even the defense's main argument that the defendant had been doing well except for this incident struggled to overcome the facts. Courts often give defendants leeway when someone makes a mistake but demonstrates genuine progress. But when the new offense closely mirrors the original criminal conduct, judges frequently see that as proof the probation hasn't worked. In the end, the judge delivered a 6-year sentence, which falls right in the middle of the 2 to 10 year range allowed for this 3rd-degree felony. Not the maximum, but clearly a strong message that the court's patience had run out. Now here's the question for you watching this case unfold. Do you think the judge made the right call by revoking probation and sending him to prison? Or should the court have given him one more opportunity to turn things around? Cases like this raise a tough reality about the justice system. Probation is meant to be a second chance, but once that chance is broken, courts often move quickly toward accountability. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.